Humbly, my lord,
In view of
pray
your
before your
circular,
lordship.
in view of your circular, it is only some thousands demand. In view of your circular,
Actually,
this is SJC.
just now I read the file.
This is SJC. So emanating from now it is ITA. So earlier it was special jurisdiction case. So up to 1 crore, I think.
Now it's 2 crore.
Now it is 2 crore. Give that circular and similar orders we were doing passing one line order.
Right.
That in view of that you are withdrawing those cases. Yes, sir. Furnish that.
Giving a circular.
Yes.
In the course of
No, that's true. He will withdraw. In view of the circular, there's a 3-line order.
Yes.
Give tomorrow.
right.
Circular. Keep it tomorrow, it will be disposed
No,
of one in one.
Why not today?
Today I give this.
Give.
Fine.
Give
In
it.
the course of.
Item number 2.
Don't record. Let him first give it.
That is clear in nature. The land, public land has been enclosed by the miscreants. And as per the government.
What is your reaction? Why the public land will remain in cross? What? Instruction 2 weeks after vacation.
Well,
Give.
item number 3.
Oh, all. Both the matters.
I want my matter to be.
The second matter?
Double PC.
Appearing in the sub-item.
Yes, sub-item. Yes.
Maybe can kindly be adjourned.
Why?
Because this matter has come up after it was directed on the last date on 2nd of September to be tagged along with the matter that they are withdrawing to.
Yeah.
Although they requested for it to be tagged. I don't know why they are
Challenging the virus of section
54 of the Odisha Municipal Act.
The notice has to go to the Advocate General. Yes. First order, just the memo is filed, the seeks to withdraw. Is withdraw. The another connected matters are detached from the.
Four.
The office by 8 to 11 has enclosed the village public road mile.
Oh,
They are doing peace business.
what are you doing? Encroaching your land.
in certain hours of the day, some people are selling to you.
Oh, they are the hawkers.
Hawkers.
Oh, then let us see. There is an act. Hawkers, the
Street
protection
vendor,
of
street
invention, I
vendor
think
standard.
there is one act.
Yes, madam. So, below, this instruction says previously they have been removed because previously a writ petition has been filed and some order has been passed. But now they have again come back. No, the same case. But some days.
I think you'll have to dedicate a particular area where the hawkers can be accommodated. I think
They have their,
where is the act? There is a central act.
they have their temporary structure on the road mile.
Sir, the hawkers are there. There is a central act.
They are not hawkers miles.
They are coming and selling and going back.
There is a, I have annexed the photograph, my lord.
What photographs?
And
What is this?
they have temporary tax construction, my lord. There.
Street vendors.
Page
One of the
23, my lord, what are they?
Where it is? I do not find.
Just
What is this?
at page 24, my lord.
There is no hawker.
Page 23, my lord.
Yes.
They are selling fish, my lord. The makeshift.
Yes, makeshift is there. What about this act? This is the street vendors, the protection of the livelihood and the regulation of the Street Vending Act.
That is a village road.
Sir, when there is a central legislation, there is a protection which has been given to these street vendors. Street means that's a public road. Street vendors means that. So in that event, if the act has come, it says an act to protect the rights of street vendors and to regulate the street vending activities and the matter connected therewith. That's an object of this act. It talks about the urban. I do not know rural. It also includes the local authority, includes the Nagar Panchayat.
You will also have a glance at page 29.
That's true. There is a complete mechanism which is provided. There should be a committee which should be constituted. Thereafter, you'll have to identify a particular place for these street vendors.
And that to settle them. Now, that's what the instruction says, my lord will see.
Because section 3, sir, it says the survey of the street vendors and protection from eviction or relocation. This is what the act is. So protection from eviction.
You also have a glance at the earlier single bench direction, my lord.
I do not know whether you are aware of this act. Please look at it. You have not made out a case of this nature. Please look at the act, section 3. So there are survey has to be conducted. There are many things which are required to be done.
That is the town building committee.
I understand. If you come to the definition of the local authority, it at page section 21C. It just previous page, sir. We are looking at section 3. Please come to 21C. Local authority at the bottom, left hand side. It includes Nagar Panchayat. That's why I'm saying that there is a committee to be constituted by them. The scheme of the act is that there should be a committee which should be constituted. The committee will make a survey that where the street vendors are there, and then they'll have to take a decision of a relocation or something of that kind. So long that the survey is not done, the protection is given under section 3. That protection is given under section 3, subsection 3. 3.3. That they cannot be evicted unless the survey is done. You are asking for a removal. How can we? These are the acts.
Pungent smell is there, waste material, and they have.
Sir, whatever be coming, can you defy the law? You are a lawyer. Sir, you should talk law. If the law has given a protection, can you argue that something is happening, something is not happening? Will the law go in this way? Please consider that. You were not aware of this act. That's why I brought to your notice that when you are moving a PIL, we can definitely direct them to constitute an immediate committee. We can direct them to immediately conduct the survey. Let them give a report. Whatever is required under the act, they have to follow. They can't go beyond that.
You have demarcated also.
No, this is what is there.
In accordance with that.
No street kind of a matter there. That's why I know. Yes. Nobody is constituting a committee. There also we have to issue a direction to constitute a committee. It should be throughout a pan, the state.
Government school is there, meaning.
Kindly look at section 27 also. Such a stringent provision.
The state has framed the rule, my lord, in pursuance to that. 2015 rule is there, my lord. My lord, there is every probability that a committee has been formed, my lord. And in fact, the instruction also says, my lord, we'll see, the last but.
It says they will not be harassed by the police. Can you imagine such a section? You will not find particularly in any statute. Very interesting section 27.
This is in Patamundai.
Patamundai.
This is a town. Patamundai is a village.
What are you talking?
Sir.
Look at section.
Council.
Very interesting section.
Village.
Very interesting.
Still,
You just disclose whether the committee has been formed, whether any survey is conducted, any proposal for relocation of those street vendors. Everything you'll have to do it under this act. Will you say whether you say committee is constituted? I do not know. You disclose whether the committee is constituted under this provision.
Says that necessary steps will be taken to settle them in another area. That is the language.
Oh, that is the first thing is the constitution of a town committee. Thereafter, the survey is to be conducted, and then after the survey, the suggestions that where they will be relocated. So they can be relocated. They can't occupy each and every street. That's not the mandate of the act. They have a protection. They have a. Because this apex court, if I remember correctly, in one of the judgment, I think the constitution makes decision that the hawking is the fundamental right they have.
Olga
Telgi, maybe. Olga Telgi, maybe. He has come up in that because if it is a fundamental right, then how can you? I think after that, this act came, that judgment. Please go through this judgment, sir. And make out when you draft a petition, you should know what is the right, what is not the right, sir. Don't draft it in a very casual manner, sir. Yes, take instructions. The accommodation is sought by the Please read this. I beseech to you to read this section, this act.
Item number 5.
Petitioner is doing liquor business, having a manufacturer and retail license.
What? On shop, off shop.
That is offshore, outside system, outside system. that-
Offshore means no consumption within the premises. I understood.
That is- And he has doing business since 2005 and 6.
2005 and 6.
While in the year 2013, there is high, the severe cyclone was there. And also there is severe flood is there, for which the entire outside system was damaged. For which, one is he has shifted to the engine cartoon, but he has shifted his outside system to engine cartoon with the permission of the collector.
Another place.
Yes, with the permission and he has paid already. In the meantime, he has already made this. And also he has applied, right, Annex 7.
That now that place is otherwise.
Yeah, that is feasible. All the it's already been deposited, and I also given, Council has given the report, that is a feasible report has been given, and also the entire.
Then what happens?
But till today, but he has not given the permission.
Sir,
That is pending that.
take a decision, either allow or reject. Again, the theory of consideration of representation comes.
That Annex 10. That entire man is, it will determine the previous place.
Place the report. D'accord. The additional government
Actually, here is the case similar, the petitioner submitted the escalation bill which was considered as a chief engineer, directed under annexure 5, the superintending agent to revisit and up to annexure 5 you also page 135. On 2nd July 2024, he directed to superintending engineer to revisit and prepare a but they have not taken any decision.
resubmit the schedule adjustment data.
And it is 2nd July 2024. And till date it has not been finalized.
What are you doing, sir?
Well, at the similar matter, the same petitioner has filed. We have filed a counter affidavit in that case, that is pending.
Other words.
It is different.
So, this is a different contract.
Sir, he is saying that he has submitted a bill. The chief engineer roads has sent it to a superintendent engineer to do a particular exercise, re-examine. You have to re-examine
I'll take report. That.
because you believe I do not dispose of to consider application. So the same order, file an affidavit disclosing any action has been taken there.
Yes.
Same order for this is subject.
Okay, it is a case, but the tender committee has relaxed some conditions for the bidders matter. And they have been technically qualified and subsequently got the contact matter. Similar matter, I have already issued notice. 3 days back matter, so.
In the same tender.
Relaxation of a condition or
Some minor defect is there, therefore they are.
23rd.
Can you see Annex 3?
Yes, yes, sir. Come, 23rd. What? Is which matter?
Item number 8 next. Item 8.
Immediately you send so that the file will be placed before me in the. It's a actual. Escalation price, they have not.
They have not, unfortunately, it's my representation, but then relating to.
Clause 31.
Sorry.
Clause 31 of the
Clause
condition of
31.
works
And what
department.
has happened-
You wanted it to be violative of Article 14.
I'm eligible to receive some escalation price. And my
But what is
representation-
this clause 31,
Clause-
which you want to be declared as
No, sir. Clause 31 clause speaks of an escalation. If they have given me an extension.
your first prayer?
My first prayer below is clause 31 of annex clause.
Please, first prayer in the writ petition.
Man, clause 31 is a price adjustment clause,
Yes.
and it says that if there
Please
is
read what you are arguing is just opposite to that. Please read.
action of the opposite parties for non-disbursement of escalation price from 8/3/2020 to 31/3/2021 as per clause 31 of the conditions of OM number so and so shall not be. I'm sorry, it's not happily worded. I'm sorry, your lordships are correct. It's not happily worded. The grievance, my lord, is only the grievance, my lord, is non-disbursement of the escalation price.
I understand. That's why I'm saying.
I'm sorry, it's not happily worded. I admit no. The
No,
second
it was
prayer,
not settled by you, that's why. It was not settled by you.
It's not.
So-
I had the unfortunate task.
Because of change of situation, you are interested with this brief.
Annex 2,
Where is clause 31?
no, Annex 2 is pending. With the.
Where is clause 31?
No, clause 31 is the phase 13.
13.
13. Price adjustment. Contract price shall be adjusted to increase.
No, what is this? Cement? Oh, 31 has many, yes.
Many
Yes.
subheads. So essentially, what has happened in this case, they have given me an extension. And for this extension, there was an escalation for the work done from the period 8/3/2020 to 31/3/2021.
No, I understand. What is this?
I'll take it.
Annex 4 may kindly be perused. Annex 4 may kindly be perused. The condition
I understand, but
and age
but-
clause is 78.
same the affidavit. to disclose whether any
Bless.
Your Lordships, this is that tender matter that had come up yesterday. I apologize for my audio yesterday. My learned colleague is in court. My Lords, if I may just hand over a brief list of dates. Now, in this matter, a tender was floated for the supply of AI towers, and I had been declared as the L1 bidder, awarded the work order. If my Lords just have this brief list of dates, my Lords will see at the top of the page on the 4th of October, 2024, the government issues a tender notification for the supply and installation of AI towers at the Debrigad Wildlife Sanctuary. My Lords, on the 8th of November, I am requested by the DFO, the District Forest
to revise, to match the price or revise the
to revise
price.
the minimum price, which was so done on the same date. I had quoted a price of 92 lakhs. Now, on the 11th of November, I'm awarded the tender as the L1 bidder. Work order is issued to me. My price quoted is 92 lakhs 74,800 in the list of dates. Now, after this, my Lords, on the 24th of December, they issue a letter, and I'd like to show that letter. This is at page 33 of my writ petition. They issue a letter saying we are now revisiting the issue and kindly stop work in the interim. At page 33, my Lords. This is a letter issued by the DFO to me on the 24th of December. With reference to the memo on the subject cited above, you're requested to kindly attend a meeting on so-and-so at 11 a.m. regarding functioning and specifications of the artificial intelligence tower real-time based for early warning system for fire, animal movement, etc. Until that, the work of the tower installation may be kindly be stalled. Thereafter, my Lords, on the 20th of January, a third party, which is opposite party 3, writes to the government saying that this entire tender process might violate their patent rights. If my Lords will kindly turn to page 50. This is very important how opposite party 3 comes into the picture. If my Lords has page 50, they write to the DFO, opposite party number 2. And if my Lords has page 50, in the middle of the page, if I may read, the fourth para, it has been brought to our attention that a tender floated by the authority for artificial intelligence-based video analytics software so-and-so is using our invention.
That's the infringement of the patent right.
That is their allegation. That is their allegation, my Lord. Now I'll show what happens. My Lords, later on, a price fixation committee is formed. Now, my Lords will see this at page 49 on the 11th of February. At page 49. Now, this is very important, my Lords. On the 11th of February, a committee, I'm reading from the top of the page, Office Order 24.
Correct.
A committee is
Committee
hereby
was
formed.
constituted to that details of the articles which you will be using in an article.
Yes, my Lords, we kindly keep one fact. My tender is finalized, price is finalized. This is all post
Sir, I understand, sir.
Now, my Lords will just see the
Not tell me, then what?
Yes. So
they raised an objection. Then what happened?
Yes. Now, my Lords will kindly turn to the price justification report, which my Lords will have at page 38.
No, I'm just talking about after this objection, what has happened?
Yes. Now, my Lords, now they go into this. The detailed finding is at page 38, my Lords.
So was there anything done? Have they taken any decision thereupon?
Yes. So in the price committee fixation report, they include my competitor, which is OP3, which is why I show the constitution. No private party was included at page 49. At page 38, on the 17th of February, there's a report. And my Lords will see that they narrate everything, how I was the L1 at page 38, annexure 8. The details.
I have not understood thereafter. if a patent holder has approached the authority and apprised him that this is what I have got a patent right, and somebody in the garb of this tender is using my product or my invention, then it violates one of the violates the
My lord, I
provision of the
follow. I
Patents
follow.
Act. So
I follow.
definitely the authorities will definitely not
The cancel. My lord,
any kind of a, the device, gadget or whatever to be
My lord,
used.
I follow. I bow down. But that is not the reason for why I was ousted. I was ousted because they say I could have done it at a lower price.
Where is the decision? Where is the
Yes, my lord.
decision? Tell me, where is the decision?
Yes, my lords will kindly turn to page 39. These are the findings of the commission. Further, the
After this
commission,
letter,
after this report, my lords,
no,
pursuant to this, my
after
tender,
20th of January 2025, what has happened? Please tell me.
after 20th of January
Because
2025,
I find a noting of 17th February
my
that
lord.
the copy of the notice sent by such and such to such and such be, I do not know, the division regarding this tender is given to, I do not know. What do you mean?
So, my lord,
Hirapur
yes, my lord,
division.
yes. So, would my lords kindly see 38? The reasoning for my cancellation is not based on their patent right, which is done.
Where is this?
Decision is at page 38. If my lords may kindly have 38.
Yes. When, what is the decision? 17 to, yes, after
Yes,
that.
the decision is to cancel my tender, and it is
Right.
not based on someone else's. If my lords may have 38,
Just 1 minute.
page 38, my lords. If I may read from the third paragraph on page 38, it will be clear to my lords.
So you could not satisfy that the system, real-time anti-poaching surveillance and the wildlife tracking system, which you are using it, that it does not offend any patent right. You have not shown anything.
Yes. So, would my lords just kindly have para 3 with me? Now, they don't cancel it based on patentry rights. They say, furthermore, it has come to the attention of the undersigned through various sources that similar AI-based stars for fire and so have been.
From where I do get it.
Yes. Para 3 at page 38. At page 38, para 3. It starts with furthermore.
Yes.
Yes. Furthermore, it came to the attention of the undersigned to various.
Paragraph 3, I am not getting it. Yes, furthermore. Yes.
Furthermore.
Yes.
It came to the attention of the undersigned through various sources.
Sir, there are multiple, sir, forget about it. We may take 50 grounds. If we find one of the ground that really creates a problem, then we can definitely say that the ultimate conclusion is correct.
But my lords, what is the price is fixed. Now you
No, that we are not concerned that they could not have done after the awarding. But what about the infringement of a patent right?
My lord, that is not the
Tell me.
ground for cancellation, my lord.
Sir,
If my lord will see,
paragraph 7,
the
at page
delegates,
39, please
yes,
come.
yes, the delegates, I'll read that, my lords. The
Yes.
delegates of Tangent Solutions could not also justify their stand relating to Indian patent, relating to real-time so-and-so, Government of India by binomial solution.
Yes,
And
show
then
us
over the page.
that what you are using is not infringing any patent right.
But
Tell
my
us.
lords, that was not the ground of cancellation. They said a price. And what do they do? My lords,
Yes, sorry, you are three? You are three?
For the petitioner, Your Lordship.
that's my colleague.
Issue notice, file your affidavits within 3 weeks. 1 week rejoinder, 4.
Absence of the CTO and restriction imposed during the COVID lockdown, my lord. On that, my lord, the petition
Can also be done like this.
non-operational period, my lord.
Decision you have taken.
Malad, we have after 2022, Milad, after he obtained the CTO, he has been allowed to work. His grievances, because previously, before he obtained the CTO, we had not issued by forms. Obviously, we could not have issued because he didn't have the consent to operate. His grievances, those 2 periods are to be adjusted and his lease is to be extended again. It is to expire in 2025.
Okay.
He said up till 2027, it is to be extended.
Oh, but that is the prayer.
That is the prayer, Milad. Extend the lease period, Milad, that's the thing.
Oh, that is annexure 10.
Well,
How can it be? Under what provision? Show me any provision from the lease deed. The court cannot rewrite an agreement for the litigant. Can the court? No, sir. Show us the provision. Where is the right? Is there any provision for extension or a renewal of the lease in the lease deed? Yes.
My lord, there is no provision, my lord, on page 22, it has been clearly written that this deed is registered for a period of 5 years. 5 years. Subject to the. No, there is no provision for extension or renewal.
Which paragraph?
Lord, at page 22, my lord, now this indenture witnessed as follows, second paragraph, my lord. The said demise pieces of riverbed shall
No,
be.
no, always in the terms and conditions there remains.
Terms and conditions do not mention, my lord, renewal.
It is.
During the 2 years, he could not operate.
He could not operate, my lord, because he did not have the pollution control board's certification.
But he says that because of the pandemic
Pandemic was also.
that struck and there was a suspension of the entire mining operation or quarry. So this is what he says, that these 2 years, and after that the consent order was given to him and then he started operating.
My lord, mining operation, my lord, that was not stopped during COVID. And my lords may see page 37. That is the consent order granted by the Pollution Control Board. It is on, my lord, it is dated 21 to 2022. My lord, we come into the picture only after this was granted by the Pollution Control Board.
No, because the lease was granted much earlier.
My lord,
So it was much before 2020.
2020, my lord. It was granted in 2020.
True. So they say that because of the COVID and the date of the execution of the lease was.
You have not issued him transit pass. So how he transport?
Oh, it was in the month of November.
November 2020.
Sir, then the country that started functioning, it was not that the entire country was, put at halt. It was an initial period from March.
I mean,
April month only.
When the lease was executed in November 2020. What was the difficulty? When the lease can be executed, then the quarry permit must be there. That you can't take advantage of that. Must be that he has not taken a clearance from the pollution.
That is not. And why form was not issued by them?
Why form will be issued only after the consent?
So when had you applied for pollution control clearance?
Mailers, annexure 2 mailers, 21 to 2022. Annexure 2, page 37.
Now when did
27 December 2021, after 1 year, he applied. And this is one of the conditions for consent to be granted to operate quarry.
Mail.
So you applied after 1 year.
Due to COVID-19 matter,
You can go for an execution and registration of a lease deed during COVID. Can you not apply for consent during COVID?
the mining officer is stated in annexure 9 mail, due to in page 45 mailers.
No. The instant writ petition is filed by the petitioner seeking
Item 11.
Additional challenge is the legal demand raised by the opposite parties.
Illegal demand.
Lordship. Because your lordship, we are not considering the fact that we have already surrendered a wide transit pass, your lordship. The pass which we require to transit,
The transit of,
lordship.
yes,
I mean, it's
yes. Why you are not issuing Y? That's form Y.
wide transit pass.
Why transit pass?
It's Annexure 3 and Annexure 7, my lord, the demand has been raised. Lord, they have not paid the government dues. They have not paid the government dues, my lord, for the financial year 2023-24.
Look at it. If you are at default, then why?
Pay such area amount because the lordship are not able to operate your lordship. If we have not extracted the amount that we were permitted, how we are liable to.
Why you were not permitted?
They have taken them away by power.
But only transit pass will only come after you excavate the minerals or mine the minerals and then you wanted to supply. So first thing is the extraction has to be done. Where is the problem? I do not know the rules.
Supply is only obstructed. How will we get our own money also to pay such a amount?
If you have already supplied earlier and if you do not pay the royalty, you do not pay the other charges, then are you there?
Previous area of the lordship.
He has raised the demand.
The year on which they have obstructed my transit, only that area is due, your lordship.
No.
Not
What it says?
Lord, page 13, my lord, Annexure 3. My lord,
Yes, it was a period, the period previous to this.
No, your lordship, it's not previous. It's the same year,
For the year 2023-24,
324. Until 23 we were operating and there are no such areas against me.
So for the period when you did not issue the transit pass, can you charge it because of your fault?
Instruction in this matter.
It's not very easy. One liner is a difficult one, sir.
My lord,
You have to be very sanguine about it
my lord.
when you submit something.
My lord,
We were swayed by your the submissions that yes, there was a default on their part in payment. No difficulty. We were swayed by that. But you will not issue a transit pass, yet you will demand that you pay the royalty charges and all the charges.
My lord, may say
Is it not?
they have worked. Annexure 2, my lords may see. We asked them to deposit the balance transit passes, my lord.
Yes.
Annexure 2, my lord.
Yes.
We asked them to deposit the balance transit passes. Why transit passes? So, my lord, it's not that all the transit passes have been asked to be deposited.
Illegal demand is raised for the whole year, not for the balance year.
No. We have said, my lord, you surrender the balance transit passes. So, my lord, they have used the transit passes, Y passes for the 2023 and 24.
Yes.
So, my lord, what the same year, 2023 and 24, my lord, on the next page 13, they're raising a demand, my lord, that they are not paid.
The whole year. Why you did not surrender the unutilized transit pass?
You surrendered the lord.
When? Where is the letter? That you have returned it?
The submission they have raised the illegal demand, your lordship.
Show us that you have complied this particular requisition made in this letter dated 22nd December.
Presentation I have mentioned, your lordship.
Where is the document that they must have given you a receipt for return of the balance Y transit pass.
Lordship, same we have not annexed, your lordship. But
Why? So you should show that we have immediately complied with.
Lordship.
So.
But your lordship, in our representation also we have taken the same plea that we have already surrendered the right transit pass.
Then let them deal with it.
I'll take instructions, my lord, on this matter.
No, file your affidavit.
My lord.
Disclose it this 2 weeks, 1 week.
Lordship, we have also filed an IA, your lordship.
Very bad.
Have you seen page 27? Second paragraph.
No, he has said.
What he says is reflected. To that extent, you have to.
You deal with it and show us. And you also, in your rejoinder, you file.
They are admitting that they have been.
1 week, 1 week
till
after
15
vacation, the
23.
counter and rejoinder 1 week thereafter. Well, 2 weeks after.
Yes.
which, give it. Next. We'll see to it. Don't worry. I'll call the next.
already written.
One minute.
Item number 13.
Sir, why are you not taking a decision, sir? What is this? There are a spate of litigations which are coming every day in the court.
We have to file a counter affidavit.
Not counter. You have to take a conscious decision. You justify that why you wanted to restrict it. What is the rationale behind it? You can sell it in a 1 liter or a 2 liter and will not permit them to sell in a 90 ml or a 100 ml or a 180 ml. What is the rationale? Either you stop completely or let them sell in whatever the measurement or a quantity they want.
Container has a discriminatory feature.
What kind of I do not know there should be some rationality in the policy.
I bow down, Miller, to my Miller. I have to bow down because I also do not see Miller, right?
So, no, if it's a complete embargo, no problem. Please give a decision, not counter. Then we'll
Maybe
stop
more
down.
than 800 cases.
Miller.
And then why are you piling it up without giving?
Let's call the next.
Item 14.
Here, and they have applied for a bird, for a pre-qualification of a bird in Paradip Port Trust.
What do you apply?
For a bird, for a BOT basis, field operated transport.
This is a port.
Oh,
You wanted a berth in the port.
to be applied, because they advertise for a bird, for a container bird, and they advertise, he applied. But if we are in the pre-qualification stage, they rejected our qualification, if a lot is at page 66, they didn't give any grounds, but in the pre-qualification rejection, your lordship sees page 66.
Stand permission. Lord, I have the instruction to appear to the law department. I got the instruction to appear. Lords may kindly.
What law department has to do?
No, not the Paradip Port. There is a copy. Lordship, I'll come back to the instructions.
Paradip Port. You are appearing.
Who is appearing for Paradip Port?
He is saying he has instructions, he is saying, Lord,
Instruction.
he has instructions to appear before.
You are appearing for whom?
We are together.
We are together.
We are together.
We are together. Just now got a mail from the Paradip Port to the copy and come with the instructions.
Sir, copies if certain, well, lordship may query day after tomorrow because they need some protection before lordship because they should not precipitate the matter by taking time before lordship send. But it's a pre-qualification, I have been disqualified. Lordship is at page 66. It is a big lot of 467.
No, you are a.
And sir, DM boxes are down below. List of applicants not qualified. If lordship page 66.
Yes.
DM boxes.
There is no reason assigned.
No reason assigned.
The bid is in two parts. One is the qualification and next is the bid.
The bid part.
I am already operating one berth. So I am qualified and I fulfill the qualification criteria.
Yes.
Notwithstanding that, because the criteria is laid down and it says that if you fulfill these criteria, then you will get it. You will go to the next stage. So we are now, the question is whether I will be bidding or not bidding.
They have not allowed me to bid. So your lordship may permit, that stage has not come, permit me to bid. Or your lordship may say.
What is the reason?
Come back to instructions.
They can
copy be sought on me.
This copy and day after tomorrow is fresh admission.
Great.
Yes.
Give.
You are so direct to the register to record a name will be recorded in the cause list.
Shakespeare says that what is there in the name? If the rose is for
for what is the order that you have appeared. So unless there is no order, the bill has not sanctioned. And that should not have been, but that happens in public sectors. The day.
So it is only in the order. He says that my name be recorded in the record.
Cost list now.
What is this? His name that he appears.
Course of the day.
He
is involved in the present application for purchase belongs. Purchase the interest of the legal fraternity of state belongs.
legal fraternity.
Including the panel lawyers of the state and central government. Everybody belongs is affected.
Oh.
Petitioner for purchase belongs. In this application challenges.
Who are you?
Because I'm practicing lawyer of this HON'BLE court. Both the petitioner belongs. And you are directly agreed.
Why?
Like, yes, there is because that now communication, they have not the well, Odisha State Bar Council first fund rules, 2020 blocks. Whereas in 2021, May 21, 14/5/2021, this rules was made effective by your notification of the council. Council was not put in place because the entire council was operated through Milot Special Committee, Constitution 8 of the Advocates Act Milots. In exercise of power, which is not available, that's not my challenge, round of challenge Milots. Special Committee
Can you not settle?
could not have been Milots. Because they kept it abeyance, you're also right saying so. They kept the matter in abeyance for 4 years. Now they have revoked their decision and they are going to implement throughout the state. And not only implement it, now in course of implementation, they threaten say that in case if you do not fix 100 rupees stamp, I will be proceeded misconduct. I will be removed from the enrollmental council. I will not be a member. Even my association will also be proceeded against by the council. There is a threat to the president, secretary, the entire team of office bearers. And they are required bearers under the rules to maintain, sorry to say, they have to maintain 2 accounts. One for accounts for the staff and for sale of staff.
Who framed these rules?
Special committee, not the council was not in place. And
I'm
after
asking.
that, if they were coordinate bench of the HON'BLE court Milots, Metro was challenged before the division bench earlier. And this HON'BLE court said that tenure of the special bench can admit 6 months under Rule 80. It cannot extend that. And the other division bench, relying upon judgment of judgment in the case of under Supreme Court said in the case of one proposition under Representative People's Act 1950 said that even if there is some defect in the electoral roll, pending rectification or revision of electoral roll, the election cannot stop. First, relying upon so many judgments say that will take its own way. Suppose by the time election approaches, your rectification is not over. Pending that election can take place. And your 6 months tenure cannot be because special committee in this what you find across the whole of the country, perhaps I can say perhaps 18 bar councils were being managed by Bar Council of India through managing management committee. And those special committees, they were functioning in absence of a regularly constituted elected body members. And whereas you could have managed for the time and the whole endeavor for constituting special committee is without to ensure that election takes place at the earliest.
So
6 months time
this decision is taken after the 6 months period.
No, they went on extending and during the period of continuous special committee, they have promulgated this rule. It is a special committee, not the Orissa State Bar Council. And when we represented various bar associations across the state represented, saying that it's painful, because why it's painful also? There was already advocates Welfare Fund Act 1987 that was put in place by an act of state legislature for our state of Orissa. Whereas 2001, Parliament enacted this Welfare Fund Act, making exclusion under section 57 saying that those states which have already have their respective Welfare Fund Act, they have to be excluded from 2001 Act. So we have been enactment of 1987 by our state legislature by making Welfare Fund Act, and your worship must be knowing that we all lawyers pursuant to that enactment are affixing 50 rupees welfare fund stamp, which is still today that is in vogue. And not only that, Orissa, because the funding for the lawyers for different budgets are so inadequate. If somebody has lots, his subscriptions expense getting 10,000. Sorry to say this, because I am the president where I was in 2020, I have come across many cases. They are not getting money even for subscriptions. They don't have money savings to meet them. And our bar association, to meet all those contingencies, formulated a own welfare fund act, welfare fund below the rules, by virtue of which we are paying 50,000 immediately, 1 lakh for medical expenses, and also medical insurance also we have done. There's all those taken, and your lordship, full bench of this Honorable Court was pleased enough to accept the resolution of the High Court Bar Association, and Rule 6A was inserted in the Orissa High Court Rules 1948. And also 6B, that is for the clerks association, by saying that if we have prescribed 50 rupees for the lawyers, senior lawyers 100 rupees. If that will not be paid, then the registry will show defect bearers, and that was inculcated in the Orissa our High Court rules laws. So a lawyer has to pay 15 rupees for bar council under the welfare fund act. 50 rupees by our own bar association fund for which the rule is amended, and we are paying for our own benefit because state is not giving us money. We are taking care of own problems. Lordship must be taking cognizance of this factor. Again, Bar Council coming up saying at the COVID period, 2020 COVID period, there was chaos, clamor all around. Then the representation came forward, including our High Court Bar Association. We said that no, this is not only this is little confiscatory. It is in addition to those you are still trying to do that. But at the same time, one is special committee would not have made this legislation because this is an essential function, legislative function.
So it was absolutely kept in abeyance for a pretty long time. Now it is sought to be enforced.
Now they have revoked it. By elected body. Now they have revoked. The elected body has now put in. They have revoked it. The kept in abeyance order of that rules which was there for last nearly 4 years. Now they are revoked, and they are directing all state bar, including the High Court Bar Registry.
Revoked means this order of suspension or the in the rule in abeyance. That is revoked.
Revoked now, and they have made communication to all constituent bar associations.
Where is the provision of law?
Provision, yes. The source of power which the Bar Council claims for promulgating this Orissa Corpus Fund rules is 15 GA 2GA read with section 6.2. The provisions which apparently is not at all applicable. You have to kindly see the advocate side. Section 6.2 also. And this levy.
Again, I am repeating that after all, from your side, something has been,
May I say one thing? Because all humility.
why not to just keep the, the sanctity, just to keep the harmony,
Correct.
sit together and then you can resolve the disputes.
They don't have power, first of all.
Or whatever.
I understand. Your logic.
Even every one of you
Correct.
are a part of that, without which you can't.
A representative from council is also from all of us.
That's why I'm saying that when I say every one of you is a part, that means
Nobody is alien to none.
correct. So everything, so you can sit together and then sort out the issues on that.
But before sorting out, how can you enforce invoking 35 misconduct? Can I be proceed misconduct? And bar associations of the entire 180 associations after
No, that's why I'm saying that a harsh decision, you can sort it out and they will.
And why this so happened after Honorable Supreme Court interpreting section 24(1) saying that you can't impose on the garb of the enrollment fee 42,000. And one more thing, let me take your also notice. I was just coming across. For the purpose of that 42,000, which are done for Supreme Court bills, one component is 5,000. A new lawyer who enters in profession is paying towards his entry into the Odisha Bar Council corpus fund rules. That is
that is not there. After that 750 rupees.
Let me show this to my lords. People, those who have entered into legal profession at the time of enrollment, they have paid 5,000 towards Odisha State Bar Council corpus fund fees. 5,000. I told you my lords. What do you say?
Before 700.
Before 750. Objective. Nobody is saying now.
Now.
You are collecting, Bar Council collecting 5,000 rupees towards this corpus fund rules. Where from you got the source of power? What can you?
Which we are collecting earlier.
How can you, under the corpus fund rules, please show my lords the provision?
It is no
under
longer
which
there.
empower the Bar Council to collect this money.
It's an
from the
academic
banks.
issue because it's no longer we are asking for that.
Mr. Sahu,
My lords.
I believe that you should sit because the moment we enter into it, it will open many Pandora boxes.
Many, yes, you're right there. Many.
So consider this and think over the matter, and then if you can amicably resolve it. Because I do not want to make any comments on that. I think the indication is sufficient enough to go to you.
So for me, but for them, perhaps.
No, many things. I have not said anything. Many things. Then it will open a full Pandora box.
Not Pandora box, in fact. There is nothing hide and seek.
Mr. Sahu,
Then if you invite me to disclose, then there will be a.
I know you are also must be knowing many things.
Mr. Sahu, as it appears, you are more anxious to resolve this issue in a litigation, not in other form.
No,
Your tenor of argument shows this.
No, not
Because after all, it belongs to a brethren fraternity. Because we encourages the brethren fraternity. So I think everybody is there. And,
also in the interest of the family.
interest of the
Associations are hurt because of their written protest to all the.
That's what I'm saying. That they are also
Rightly said.
they are not ones in that sense, or there is another word. You should use it or not. I do not know. If you permit and do not take it amiss, then I can use that word.
It is the Bar Council who can do
Bar
it.
Council can make a consultative process with certain members of the Bar
165
Association.
bars have already implemented it.
That is not the criteria for the legality of it. We are not
Legality
getting into
we are not
it. So far as the discussion is concerned or amicable discussion is concerned, it should involve all the stakeholders.
All the stakeholders and
You just sit and do not insist, do not take those harsh decisions in that way. After all, they are all a part of you. So why don't you sit together and resolve it?
We fight with all our might by not come together.
Do not invite the court to decide all these causes.
Bar Council can take a call.
No, what bar council? Everybody. Sir, you cannot segregate yourself from the bar council.
That is true.
Nor the bar council can
No,
take a.
Bar council can call all the bar officials and.
So they can, you can sit only sentiments, as you said, is hard because of the strong languages which they have used.
Basically.
So I think there are ways and means to resolve it. Why don't you say?
We will do, Malo.
So the losses may keep it to some date in November. In the meantime, they can.
November also may keep this back.
There can be a process of.
Do not take recourse to that harsh. Considering the gamut of disputes.
And in the meantime, compare.
They have already assured. I think all our responsible officer, they know it. When they say they are not going to take
The additional basic was contracted license under the Orissa Value Tax Act. Which after implementation of the GST RTLR sales, he has never executed any works like that. So he was also never migrated to the GST rules. But assessment order has been passed under section 62, pursuant to which I have also approached to file the appeal also that as per page 30 will say that because of the technical glitch I did not file. So my limited clear will consider
technical glitch.
yes, yes. Because I was
What is the technical glitch?
page 29 also I have filed the appeal and page 30 is the help desk report will say that states this is help desk automated response text version that is thanks we are working on the issue reported and will updating soon
Okay, then
and now till date it is not resolved in the suit.
What are the-
limited clearance I file appeal
if he has filed a appeal within the time and uploaded it,
Wait, 2019, the order has been passed. 2020, the rectification order has been passed, which he wants to challenge in 2024, January 2024.
Correct.
January 2024, he has filed, he has submitted this. And after that, in the month of June 2023, he has filed the appeal. without even a small request to the appellate authority, locally appellate authority, he has moved this application in 2025, Your Lordship. So in order to cover up all the delay, 2019 and 2020, the orders have been passed. Until 2024, he was remained silent, Your Lordship. And 2020, after 4 years, 2024.
Will you refuse to accept the appeal? Now you reject it, no problem. There is no difficulty. Can you refuse the registration of an appeal? So why you are not registering the appeal? Dismiss whatever you want to do it, dismiss. But registration can you deny?
Your Lordship, only what I have taken instruction and telephonic instruction. The temporary ID, Your Lordship.
That is, you have generated temporary ID. You have generated.
That temporary generation ID is valid for a limited period for the filing of appeal, Your Lordship.
So they filed an appeal.
So if on request, that can be extended. If you are not seeing,
Sir, please come to page 29.
Your Lordship.
Please come.
I'm on that page.
GSTIN, temporary ID, UIN number you have given.
Your Lordship.
Legal name you have given.
Your Lordship.
Then you have given an address.
Your Lordship.
Then you show error. Something seems to have gone wrong while processing your request.
Your Lordship.
Please try again after some time on self-service portal with screenshot and timely. It still persists. Other type you said. Then the paragraph, the page 30.
Right.
Then it's a help desk that I have done it. I do not know what is the status. You say we are working on the issue reported and will update you soon. He says that you have not updated him soon. Soon has gone. It has now become later. When you will work on it and report to him.
Your Lordship, it is the help desk of GST.
Whatever, sir. When you say that, yes, you have seen that, yes, he has uploaded, and then you say that something has gone wrong, there is some error, and thereafter we are working on it, then will you not work on the error? It's an error, you admit.
Yes.
So, is the error on your part?
Your Lordship, what might be?
Resolve it.
Only my, yes, yes.
Resolve it.
Your Lordship.
Skipping the matter after immediately, and in the meantime you instruct to resolve this error. If there is a very, very fatal error, communicate that this is a fatal error.
Your Lordship.
You can't deny the registration.
Only what might be the error? What might be the error? Only, Your Lordship.
Yes, tell me. Sir, you have admitted the error. So will you not remove or resolve the error?
Your Lordship.
Communicate. Communicate.
Then supposition, presupposition won't be.
On 8th.
Item 18.
To take instruction.
Your Lordship, his temporary ID will be extended, let him file.
Whatever, sir. Then you will give a new filing number when she wanted. Again, you will come, delay.
Your Lordship,
You are
2020.
For the delay. Now you are citing a delay. Then you say for the delay.
From 2020 to 2020.
Whatever.
Already delayed.
Already delayed.
Yesterday you are citing human error.
Yes, called
Item 18.
Yes, Lordship.
ECB.
Paying for the basis, Lordship.
Where is the order of the cancellation of registration?
Cancellation, Lordship, under Rule 21A. Whereas I have 5 years agreement which I have annexed in Annexure 5, Lordship. That will be continue till 25th of September of this month.
Orders
Permitted to make an inquiry. Here the cancellation is not for non-filing of return, Your Lordship.
Okay, then.
As regularly Your Lordship passed order.
Correct.
Here the cancellation is at page 19.
Not conduct.
Declared there does not conduct any business from declared place of business.
Correct.
From 2024, 6/9/2024, this is happening. But this must be basing on inquiry report. So he has not enclosed any further document that he has continued his business. So,
Sir, the difficulty was he not uploading his return periodically?
no,
No.
no.
Yes, I am uploading return till.
How can you return? How can you upload the return? Your RC has been cancelled.
Oh, after the cancellation, before cancellation, was he not?
My return.
Because your perception comes that he is not working from a declared place.
You have to make an inquiry.
So before you come to a conclusion, was he not uploading everything from that place?
That your lordship, I have to make an inquiry because place of business is also a criteria.
Should this show cause notice?
That is a criteria, your lordship. Show cause notice has been issued.
Yes, your file response.
Yes. Next.
Item 19.
You better file response.
Your
May I
lordship.
please, your lordship?
Verify this status regarding.
Your lordship, I'll make an inquiry and I'll submit the inquiry.
Yes.
Returns, whether you
May I
are
please?
filing the returns to be filed beyond
2 week, 1 week matter to appear after 3.
Item 19.
Item 19, your lordship.
2 for comfort, 1 for rejoinder.
May I please, your lordship? This is a 73(4)(b) matter, your lordship. It's a service tax matter.
Yes. Give.
Item M.
Sub item also.
Sub item also same, your lordship.
Order time.
Yes, next.
Item 20.
Obliged.
Absent from this, you have the first of the order.
SLP.
Similar order in past, but my humble prayer is that one line may might be observed that the petitioner has deposited the entire demanded tax. And the opposite party revenue is now insisting to pay the interest and burden. That line may be observed.
But you pay the tax 10%.
Now, I have already paid the entire demanded tax amount.
There is one order which I have passed
So gonna be.
also to deposit that for penalty and the interest. Anyhow. Yes.
Item 21.
Item relates to issuance of notice under section 148 of the Income Tax Act by the jurisdictional assessment of instead of the faceless assessment.
I think last time we have already.
Instruction have given a decision of various honorable high court.
No, our decision was also there.
Well,
We have taken a decision.
that is going to 10th October, right? It's still a matter.
This case you did not publishing the required documents. This one.
That is what is there. Is notice under section 145(8) is not issued in a faceless manner.
This matter we have already claimed. The last
Yes,
yes, that one. Last sub item, I have given a bunch of decisions. Last sub item of this matter.
Last one.
Sub item, I have given a bunch of decisions of various honorable high courts, and in 2 cases.
No, we have also taken into consideration the Telangana, the decision of the Telangana High Court in Venkataramana Reddy Patlula.
SLP has been dismissed.
And where it was SLP has been dismissed.
In Bombay High Court decision, SLP has also been dismissed. That I have given in my bond. The last sub item.
Decided anything. We have not decided anything.
We have not decided anything. We have directed the matter to be listed on 10th of October. So let it also come on 10th of October.
We have not interfered on this point with regard to that matter which was addressed by Mr. Jagabandhu Saul. So we did not, but that is now under review. But on other cases, we have he has sought for instructions, so we are keeping it.
This matter on 10th.
This order may be passed.
Yes.
This order may be passed. In all the 4 items, right? Your phone numbers on items.
Just send it back.
And correcting, getting the necessary corrections.
Please do that. It's called the next.
22.
Here belongs the petitioner deals with fertilizers. So far as fertilizers are concerned, the lordship knows that there is the input is more than the output. And now this matter is before the GST Council, and now it has been referred to a law committee. Problem here, Lord, is because of the inverted duty structure, I got a refund, Lords, because my inputs are taxed at a higher rate and my outputs are taxed at a lower rate.
That is accumulated.
Accumulated. So the accumulated
So that
ITC
never will get exhausted.
and I so I got a refund. The refund was given to me. Then thereafter, an audit was conducted, and in the audit they say that since fertilizer is 5% input, 5% output, therefore, if the rate of tax being equal, there is no inverted structure. But unfortunately, Lords, there's another input which I am using, which is taxed at the rate of 18%. So, and 12% also means. Similar matters for the issue was before the Honorable Court for 1920 and 2021. And the Lordship have interfered with this matter. And similar matters are also before the of this petitioner, before the Honorable Gujarat High Court and Honorable Calcutta High Court, where they have already got stayed so far as this proposed notices are concerned. So far as our High Court is concerned, Lords, the first one, this WPC 15658 of 2024, is for the period 1920. And the second one is WPC 30019 of 2024, is for the period 2021. And the present petition is for the period 21-22. And so far as the
There is a restriction under section 54(3).
Yes, yes.
The restriction is put upon under subsection 3 of section 54.
And that has been challenged before, and the Supreme Court has declared it is intravirus. So on the issue, only during since the issue is pending for GST Council, for that reason this case has been admitted, for clarity.
But GST Council must have realized the difficulties faced by such people.
Now the new structure has come from yesterday.
Even if the new structure is coming, this issue related
because there will be only two slabs, no further.
This particular issue relating to fertilizer is still pending. And
it's only 5 and 18.
No, not
now. Only two slabs. 5 or 18.
5 or 18.
That remains 5. I think 5.
I have in this present case, I have an input of 12% and 18% also.
So you claim to refund.
I got
utilized or accumulated
ITC. I got that.
So which never goes adjusted.
Because of the inversion. And if your Lordship would see the GST Council meeting as annexed laws, that's at Annexure 9 at 840.
Output is lesser taxable
because
than your inputs.
And the GST Council now, if your Lordship would see, Annexure 9 begins at page 115 and page 125, if the Lordship would kindly see, paragraph 4.20.
What the income tax authorities are doing on this?
No, GST. It's a GST.
Right.
Item 28.
And it will also directed the opposite of board to provide a copy of the advertisement by an affidavit. Last night I received this in my. I will verify.
Out of vacation, yes. Time to file affidavit is extended by a week from this.
They have already filed it, it has inevitably not come up because we filed it yesterday. So the
Right.
question asked the registry to it on record.
Item 29.
I will let them file a translated copy of that.
Whatever, they let they will file.
Oriya but nothing.
Yes.
29.
Yes. In this case, we have applied for the certified copy of the orders. We have already similar. In course of the and filing the national care of this after vacation.
After vacation.
Item 30.
Item 29, I had prepared a counter. I was the respondent number 6.
File something.
Item 30.
It was like my file challenging the judgment of the honorable single judge dismissed the writ petition. But little bit background ballot. There is a the petitioners were the present petitioner was employed under the settlement organization. Well, the government came out in 31st January 2018, came out with the resolution that the expert persons, they will be, for their services required for high-tech survey. So some posts are directed to be created and special posts are created and the excavator posts were created and these persons were deputed from settlement department. Deputed means they were observed in the freshly reputed. Malad, may kindly see page 58, Malad. Page 58, Malad.
Your grievance is the designation.
There is not only designation matter, but also the cadre also. They cannot be repatriated to the original cadre. They cannot repatriate to the original cadre. They were observed in the another cadre, another ex cadre, and that
not on deputation.
Not on deputation. That is the mistake. Not on deputation. So kindly see. It is by virtue of the government resolution, my lord. It is the posts were created. After the posts were created,
What is for the other side?
And not only that, from level 9 now they have been reduced to level 3.
Well, their substantive appointment is court pescar.
Correct.
They were the pescar. That is the substantive appointment. Now, by virtue of a government resolution, they were only entrusted to do some work of revenue inspector.
Which was of a temporary or perennial in nature?
Perennial. It was of
the temporary in nature and subsequently he has been brought to his own cadre of court pescar. So how he is agreed, that is the...
My lord, you also will sit for the government order, the resolution is under Article 166 of the Constitution of India.
Where is the policy?
My lord, page 58, my lord.
58.
Annexure 9. The director, land record has no authority whatsoever to. My lord,
Just one.
I'm sorry, my lord. The gazette notification at period page 61. Page 61, my lord. Gazette notification. It has been decided by the It has been decided by the government to undertake the operation of land survey and settlement for expressly through high-tech method all over the state. I'm extending this up.
Yes, then, yes, I have seen page 58.
Well, page 58 or question.
Yes.
Well, page 58 or can we look at this? The government created this specific.
These posts were created in that particular, in the revenue cadre, but they will not be considered in a regular existing.
Ex-cadre.
Ex-cadre.
Ex-cadre. Well, Lordship will find the para 4 also, the above posts that are specifically catered for the purpose of high-tech survey work.
Until the last one retires.
Right.
Yes.
And also the in case of last also para 7, in case of a difficult or doubt arises, the implementing the above clause matters are reported to the government in Revenue Disaster Management Department. And the also kindly see the petitioner's posting method. Petitioner's posting is as per this selected petitioner's posting is that is at page 77 minus. There are page 77. There are page 77. Allowed by kindly.
Yes, you have been deployed.
Board's letter dated so and so. The following employees of the Kotak Mutual Settlement have been deployed to carry out arbitrarily in Kotak district.
No difficulty.
Sorry, madam.
You have been employed under that.
Yes,
this scheme.
Okay. And serial number 3 is the present petitioner, madam.
Yes.
The posts were specifically created for the purpose. Lordship will find posts were specifically created for the purpose, and the separate scale of pay was also prescribed for that purpose.
Yes.
Melody Lordship can see page 17, annex 18.
You will be your designation was Amin.
Amin and
sorry, RI. Your designation is RI.
RI. And your Lordship will find from the
is the revenue inspector.
Yes, revenue inspector.
Who?
And page 80 your Lordship will find this scale of pay was also determined.
Then
for the scale of pay in that scale also
is also if it is higher, you will continue to receive higher.
So, my lord, my humble submission is that
your original cadre would remain.
No,
if you are promoted from there.
But ultimate cadre will also kindly see the para 5 of that page 59. What is there in the lien? Because that is not, they are not appointed, deployed for temporary base purpose.
No, but there is one clause. It says that in case of any promotion, your promotion will be considered as the original cadre.
What is the meaning of that para 5?
Correct.
I was also attention to that, page 59.
Yes.
The lien of the employee shall not be suspended in the post under the original cadre on such deployment.
Correct.
Accordingly, the promotion shall be considered as per the gradation list prepared in the basis of the seniority in the original cadre. After getting promotion in the original cadre, the employee shall be.
Then you will be adjusted. You will be adjusted apropos to the same scale of pay.
Appropriate equivalent post created by the revenue organization.
Correct.
That is the purpose. The
purpose is that your scale of pay will not be reduced in any sense.
But what they have done, they have redeployed. This is the.
They have repatriated you to original cadre.
Repatriation, my humble submission is that the land record doesn't have the authority to repatriate the.
How? Because if we look at it, it will continue until the last person who is now posted retires. So it's a perennial in nature till he attains the superannuation.
Your Lordship will look at that resolution. Lordship may kindly see that resolution.
Paragraph 4, the above posts that are specifically created for the purpose of a high-tech survey work shall continue under the revenue organization till the retirement of the last employee in the bottom post of the cadre under such and such organization.
If your Lordship will look at page 61 of that specific resolution.
Yes.
It has been decided by the government.
The same document.
Same document.
Yes.
Operation of the land survey and settlements work expeditiously through high-tech method all over the state to prepare land records.
Correct.
After successful execution of survey work in 9 districts on a pilot basis, it is being contemplated now to carry out the work in tehsils of the state. In order to carry out the above
survey work, adopting high-tech methods smoothly and additional technical manpower is required in the post of revenue supervisor, revenue inspector, and AMI. At present, existing employees with experience and expertise in the field are working in the Directorate of Land Record and Survey and Consolidation. With a view to utilize their service of the above employees in the survey work, government has been pleased to deploy them against, the word is deploy them against the vacant posts of revenue supervisor, revenue inspector, and AMI under the revenue organization for the high-tech work with following terms and conditions.
Correct.
The employee working as head draftsman, assistant draftsman, sirestadar, so and so,
Shall be deployed in a revenue organization to work as a.
The word used is deployed.
Correct. What is the meaning of the word deploy? I will come.
Similarly, existing inspector, Pescar, petitioner, the appellant was a Pescar, and draftsman shall be deployed to work in.
As a revenue inspector, no difficulty.
Yes. So deployment doesn't.
What is the meaning of the word deployment? I am just asking you. There are two ways. One is if the scheme is of a duration, and once the scheme is fulfilled, they will repatriate to their organization. But if it is of a continuous thing, that it will continue as it appears from the object that it should continue. And then if the scheme says that till the retirement is achieved, they would remain there. Though they will not be taken in a regular cadre of the revenue department or organization. But maybe as the ex-cadre post, they are created. Designation has changed. Yet they would keep a lien of their original, the posting or a post. And if according to that cadre, their term to get a promotion comes, then the promotion would be given to them, taking into account the original cadre position. They will not be repatriated. They will also be designated accordingly, and in equivalent posts, they will be allowed to continue till they attain the superannuation. That is what the total scheme that comes out. Where is the provision for repatriation? Unless they seek for repatriation. File your response. 2 weeks, 1 week rejoinder, 3 weeks after vacation.
Item 31.
You are discharging, don't worry.
No, we have one protest we have joined. Two of us. One protest we have done.
Yes. 31.
Yes, ma'am. Connected to AL matter, I am for the petition.
Hello, dear. Challenge or judgment of the ordinance being judged. Dismissing the application. Hello, since 1966, petitioner's father was in possession of a land, that is the Dorbar land, and has constructed house and residing there. But in 2000, proceeding under prevention land encroachment was initiated against the petitioner. And on inquiry, Consular found that I am entitled for settlement under section 8A of the Act. Because 8A of the OPL Act clearly provides if a person is under possession for 30 years knowledge of the government, then he is entitled for settlement. But he recommended the to sub-collector, because sub-collector is the authority to settle. Well, sub-collector passed the order for settlement, but it is to way back in 2001. Thereafter, the pata was corrected accordingly in my name. And I also paid, I've been paying revenue receipt, and also my house is also there for our municipal receipts and all that. I've been paying my road. But 2023, suddenly Tahsildar stopped accepting the rent, saying that no, your land has been changed, you will not accept. So when I found that Tahsildar has been relying on a 2006 order of the sub-collector, Tahsildar has made the correction. That will also kindly see page 48. I challenge that before this single judge. Page 48, my lord. Where with the order passed by the sub-collector Bhadraki lease. It is not a lease case. The settlement is not under lease case. Lease case is either not a lease principles or Odisha Common Land Settlement Act. So it is a lease case on the 1 January 2000, order number 311 in 2000, sub-collector Bhadrak has been pleased to return the LCR along with cancellation of lease. The sub-collector Bhadrak has been pleased to cancel the lease transfer as per the report of the audit para 4. An impugned order passed to the lower court has been cancelled or set aside. The Basdapur has been directed to restore the lease land to original khata number so and so. However, in the original case record was called for the additional district magistrate Bhadrak, right office letter number such and such, submitted right office letter number such and such, but the documentation number from
what is this order? What is this? 14724?
Yeah.
What is this writ petition?
That is the PIL.
That is the PIL. He has, I do not know what is there because I have not been noticed as yet in that case. Well, and your lordship will also find the sub-collector's order, my lord. Sub-collector's order is at page 50. That 11/7/2006. All these orders are passed behind my back. Sub-collector doesn't have that power to cancel any. Yes, because this settlement either he has to prefer appeal or revision, anything to be done under section 12. There is no provision for cancellation by the same authority. And the appeal provision, your lordship will see the section 12, there is no appeal, no revision, nothing of this sort to have forum. So this order was passed somewhere 11/7/2006. That was kept under the carpet. 23, suddenly the sub-collector comes and takes up the issue and stopped the thing. And when I challenged it up before the Honorable interim order passed by the Honorable.
Where is the lease? Lease was executed in favor of your predecessor.
Only a settlement.
No, you said that your father or a husband or whatever was granted a lease.
But page 28, my lord. Not a lease, my lord. Lease is wrong. Page 28, my lord. As per the relying on the findings.
What is this encroacher is present?
Yes, in view of the number frontier, they are settling in favor of Ramchandra Manti.
Where do I get it?
OPL Act. And you'll also can see section 80 of the OPL Act. Section 80 of the OPL Act. And this was passed in 2001. This order had been carried out, and I have filed, my lord. I have filed the revenue, the POTA, my lord. Next page, the POTA and my revenue receipts, and also I have been accepted as a riot, and the holding tax also. I have filed prepared the holding tax to concerned municipal council as notified area council. And accordingly, I was in possession of it. Section 80 of the lordship can see the way. This is not a lease. Lease is granted under two provisions, either Government Land Settlement Act or under the lease principles. These are the two provisions under which lease can be granted to anybody. A lease stands at a total different footing, and settlement is because by
this order says that you are entitled to a settlement by virtue of section 8A of the OPL Act.
OPL Act.
So then this order was this is order passed by Tahsildar.
No, by the sub-collector, because sub-collector is authority to pass that order.
So
Tahsildar will recommend to the sub-collector.
Now what happened thereafter?
My ROR was changed. My next page, my lord, my ROR was there. So it's settled in my name as Sthitiman property. And then, my lord, my rent receipt, page 31, my lord, I have been paying rent from 2001 itself.
Then
I have been also, my lord, 2023, when the Tahsildar stopped taking rent from me, every year I used to pay
So
rent.
that was a case of 2001.
Yes.
So you remained there till 2023
Pay rent and holding receipt. My house is there.
for 23 years.
For 23 years.
Then what is the PIL? What order is passed in the PIL?
I have not noticed in the PIL.
What order? Because he refers to an order of the PIL. What order is passed in the PIL?
Got the orders from I got the orders from Lordship's website, my lord. All the orders, not a single order is there to cancel or something like that, my lord. There is no order from. The Lordship kindly said this is order. Rather,
This is the order of 9/3. And this was the order of the sub-collector on that is 2001.
2001, my lord.
So that order, the order was 9/3/2023 is not that order.
No. Lordship will see from the PIL order sheet I have downloaded from the mail. That on 12/7/22 also Lordships have categorically held that no notice has been served on the opposite party, though I was a party to the PIL, but no notice has been served as been specifically referred. And it has been said that after
that was in relation to 2006 order of the sub-collector cancelling the settlement in the encroachment case number. So your case is not a case number 17.
My case is that it is not a case of lease. And
settlement. I am asking, is it a case number 171 of 2000?
171 is the case number. The encroachment case number is 171.
Your case.
Your case is 171. Is the page 23 Lordship case number is 171. But that is not a lease. That is a.
I understand. Sir, let me understand.
Page 40 also Lordship will find that.
Seek instruction. Then.
So, my lord, because it has been settled under the statute. Now, what has happened, my lord, only single judge, without considering all these aspects, have simply directed to vacate the premises in 1 year, 1 month, and thereafter, if they do not, he doesn't do it, then it will be taken in accordance with law. As a result of which now the bulldozer is standing on my door, my lord. Because the Lordship kindly see the impugned order, my lord, the order of the unruled single judge, my lord. Page 60, my lord. It starts from page 60. The Lordship has noted down the contents. Then after.
No, this proceeding very interesting. Where it has gone. The earlier one.
Page 28, man.
I have opened both.
Yes.
Oh. One earlier.
WML.
Page 28, my lord. The settlement is there at page 28. The right has already approved to me a birth of the settlement, and I have been accepted as a right by the government, constituent right of the government, under the state measure.
No, this order does not ask for any eviction. Rather, it has been settled in your favor.
That's what I'm saying, my lord. It has been settled in my favor as per section 8A of the.
Then what is the question of implementation? Implementation means that the settlement has to be given to you.
No, settlement has already been done, my lord. Now, what has happened by virtue of the impugned order? Now, that order has been changed by the supplier.
Where is the impugned order?
My lord, that page 50 or so, first, thereafter page 48. Page 50, my lord, sub-collector's order. Page 50.
This is what is this miscellaneous case number 320?
Yes.
What is this?
Page 51 is the concerned case, my lord, para 3. Lease case 171/2000. Now, they treat it as the lease case. And as per the report of audit para, Lordship, audit by page 51. Page 51. As per report of audit para 4, settlement of the case will be cancelled. Cancelled. And submission to RDC for confirmation, the cancellation settlement be made.
But this is the cancellation is also by sub-collector.
By the sub-collector.
On what proceeding?
Yes, I do not know in what proceeding, but this is the order passed by the sub-collector, based on which 17 years after the thousand. Sorry, madam.
He has written this. Report of audit para 4.
Audit para 4. I do not know what is audit para 4. This has not been intimated to me, or I have not been noticed in that regard, madam. So these are. And 2006
audit report.
Case number 1.
Lease case, lease case, my lord. That is the case number of
lease case.
That is the case number of the prevention land enforcement case.
Perhaps the audit which was conducted in the office of sub-collector or the Tahsil, the audit report must have come under the notion that
lease case, the lease has been done. Might have been. Might have been, my lord. Might have been, I do not know.
Arising out of a lease case.
Might have
That
been.
is why this
Might have been, my lord. Might have been. But the thing is that this one line order, cancellation.
But I am unable to comprehend the facts. Actually, what you have referred to me was that it was a settlement case.
Yes, no, it was a settlement under section 8A.
That is a settlement case.
Yes, that is settlement case.
That was not a case relating to cancellation of lease or grant of lease.
No.
But I find from page 48
Yes, my lord.
that order passed by the sub-collector in a lease case number 171.
That's what I am saying.
Serial number 3 dated 11/7/2006. What is that order? 11/7.
What is that page 51? 50 relevant page, page 51.
Now, this is a settlement case, land is cancelled.
Settlement of the case land is cancelled. As per Padata, settlement of case land is cancelled. This is lease case. I don't know how it is can be cancelled by the same person. That authority here doesn't have the authority because the statutory it is governed by the statute.
have you seen order dated 12/7/2022 in writ petition?
Well, it is seen that.
It's a very clumsy one. Find any.
12/7/2022.
Give me a word.
Well,
Read that one.
I think it is in his writ petition. Mr. Sanapati, you can
Yes, my lord.
use that.
my lord, can use
Paragraph
Yes, how this, because the very first line of this page, what I find is the initiation of the proceeding is an encroachment case.
Yes, encroachment case.
Yes. It can't be a lease case.
It's not a lease case.
Secondly, if the sub-collector has already passed an order,
Yes.
then whether the sub-collector can review its own order? Is there any provision under the OPLE Act giving power to the sub-collector to review its own order?
May I submit my lord?
Yes, tell me.
And here the sub-collector has not reviewed. The sub-collector has only said that in view of the audit objection, it can only be cancelled.
Would not that
Sir, it is not tantamounting to review.
Yes.
What are you saying? Can he? Audit objection may come. That was in relation to a land revenue.
That is why I am inviting attention to order dated 12/7/2022 in his writ petition. Perhaps this court was not.
He was not apprised of the correct facts.
Correct facts.
It was
That is
not.
what I am saying. But
Sorry, we can't.
petition he is-
Absolutely wrong.
May I submit my lord?
Yes, please show us the power of the sub-collector to review its order.
My lord.
If the order is passed in 2001, can he review its own order? Tell me.
Only on the ground of fraud.
What?
Fraud vitiates everything.
That means no proceeding is required, fraud vitiates everything. There must be a collateral proceeding.
My lord.
What is a collateral proceeding?
My lord, there is no,
Under what provision of law? Tell me.
there is no dispute over the position of law
Then
that every tribunal, every court enjoys the power to recall its own order if it is obtained by fraud. There is no.
that is inherent.
Every tribunal, my lord, if it is obtained by fraud. Your lordship may kindly see what has happened in this
Very
case,
interesting proposition of law. I'm just trying. I know from Lazarus state judgment that the fraud unravels
every
everything.
judicial act.
Not judicial act.
Every-
Unravels anything.
My lord.
I am conscious.
My lord. Only your
The
lordship.
fraud, mere alleging of fraud will do.
My lord, that is your lordship may give me only 5 minutes. I'll submit, my lord. What has happened in this case? Your lordship may kindly permit me to place the reference in my PIL page 31. I'll take only 5 minutes, my lord. I'll clarify what has happened. Page 31 in my PIL.
Correct.
Page 31, your lordship may kindly see. Ramkumar Mahanti was a government employee. The person in whose name it has been settled, he is no more. Recently, 1 year before, he is there.
First of all, show us
My lord.
where the sub-collector has taken reports under the statute
My lord.
to touch his own order.
That is on the basis of fraud, my lord.
Sir, tell me, nothing has come out. There says that the audit.
That is your lordship, I am submitting.
I am asking you, there must be a power eminent in him to do it.
That is your lordship inherent in every court, my lord. If I obtain an order by fraud,
I think,
Yes, that is- your lordship may kindly-
we have to go back to 1952
Your lordship-
Supreme
your
Court
lordship may kindly give me
and
only-
then find out the solution and the law proposition which you really wanted to
My lord.
say.
Your lordship may kindly give me 5 minutes.
So there are two types of review.
My lord.
If it is a procedural review, there is no difficulty that even if there is no power, one can do it. But if it is a substantive review, then it must emanate from the statutory powers. It is a substantive review.
Your lordship may only, my lord, some aspects on the fact.
Facts may be very ugly.
My lord.
Law is standing in your way. Tell me.
That your lordship, my respectful submission, every tribunal and every court, your lordship, if someone has obtained fraud,
So even this court,
my lord,
after passing an order,
my lord,
let us go. Not this court. There is a judgment. I will not. There's a wrong example I will be giving. Not High Court. Suppose, say the District Court. District Court passed a judgment, and then he realized that after signing or delivery of judgment, he realized, "Arey, this has been obtained by fraud." He's plenary power.
If it is fraud,
There, again I'm saying,
my lord,
to that extent, show me one judgment.
yes, your lordship.
Sure,
Your lordship may just to make it one passover, I'll show that judgment.
please. That, again I'm saying,
Yes,
it
sir.
is not High Court, I'm not saying.
No, my lord, not High Court.
There is a
Any
constitution
court, any-
decision that even if there is no provision for a review, High Court being a constitutional court,
Yes.
that enjoins the power of review. There is no difficulty.
Definitely.
I am conscious of the proposition.
Other tribunals, those who do not have power of review, when an order is obtained by sheer fraud, that tribunal, every tribunal has inherent power to recall it. Yes, your lordship. Only one passover, my lord, may give.
The review its own order.
Yes.
Not recall.
Recall, my lord. I am not saying review, my lord.
Because,
Recall.
okay, it's a review of the order.
No, not review. This is recall. of the order.
Recall.
And my lord may kindly give me only 5 minutes. What has happened in this case, I'll place. He is a government employee. He is filing an application that I am a laborer and the land be settled. The land is a road land. It is a road we are using and that is the PIL, my lord. It is a road land. And he is a person having 10 acres of land in his name. He is not a landless person. See, he suppressed everything. He filed an application that I am a laborer. My earning is 3,000 and I require land for construction of house.
That is the consideration under OGLS Act, not under OPLA.
OPLA, 8A, your lordship initiates If there is a proceeding
Sir,
under section 7.
That is under OGLS Act.
I understand, my lord.
This is not OGLS case. This is OPLE.
This is OPLE. OPLE under section 8A, a land can be settled when there is a proceeding under section 7.
Sir, I am asking you, the section 8A does not, if correctly I understood, does not require the landless person, homeless person or anything. If he is found in settled position for more than 30 years in respect of a land not belonging to him or a government land, then under that provision, he is entitled to get his land settled in his favor. Whether he is a government employee, he is a private employee, is immaterial. What is material is the settled position for nearly 30 years or more, if I am not wrong. Is it that section 8A?
Exactly, that is the language. May I read?
If that being the position, how we will enter into that aspect? Settlement is only one consideration. Was he in possession of the land without any authority for more than 30 years?
My lord.
If the authority found he is in possession for more than 30 years, the investigation report suggests, everything, the material suggests, can you say this? Is it a fraud relatable to an action or a decision?
That is exactly your lordship under section 8A. I am reading. Your lordship.
Please.
8A settlement, 8A of OPLE Act.
Correct.
8A settlement of land in cases of encroachment for more than 30 years.
True.
Where in the course of any proceeding instituted under section 4, 6, 7 or 8 against any person unauthorizedly occupying any land, it is proved by such person that he has been in actual, continuous and undisputed occupation of the land for more than 30 years. By the date of institution of the proceeding, the tahsildars have referred the case to sub-divisional officer. And thereafter other things have been said.
So what are the criteria?
My lord.
Only one?
Only
one criteria.
My lord, the only one criteria that he must be in possession of 30 years comes.
That's all?
Comes, your lordship. It comes when there is a proceeding under section 4, 6, 7 or 8.
Whatever, sir. It may be an erroneous order, cannot be an order obtained on fraud.
My lord, the proceeding under which 8A was initiated, that is originally a proceeding under section 7.
We are staying. We are not concerned with this.
And that
we are not happy with the interpretation.
My lord, that my some respectful submission, my lord. 8A proceeding
the trial court dismissed
I will appear for respondent number 4 in this case.
Oh, then it's all right.
My
Then
learned
res-
senior may give a copy to me. I'll file Wakalatnama. I have instruction to appease.
Give him a copy here. Here and now.
Yes, yes.
Here and now, sir. Give him a copy. Yes, well,
Item number 32.
Sir, here is the petitioner is a trader of iron ore. Trader of iron ore.
Okay.
He participated in the tender. He participated in a tender for quantity of 4021.58 metric ton of iron ore. That he became successful there.
Calibrated iron ore.
Yes. So the
Specified
lump ore. I'm sorry. Lump ore.
lump ores.
Lump ore. Now, when he became successful. He deposited the entire money. He has to lift it within the time provided in the transit permit issued by the mining authority. Now, mining authority issued a transit permit for a specific period. Out of 4,021 metric ton of ore which was allocated to me, he has lifted almost 50% beyond, above 50% he lifted it. Balance 1981 of metric ton of iron ore remained there on the spot in the law. Now, point is, when he was lifting it, he found that the quality of the iron ore, the percentage of iron ore that was advertised and that was being lifted is less. That's a factual aspect. That I will not take ownership to that issue. That's a factual aspect. But the petitioner wanted some more time. That is in fact permissible in the tender to lift it. He applied, please grant me some more time because there are difficulties in view of the lower percentage of iron ore I am lifting. The buyer is not agreeing to purchase from me. And also there are certain genuine difficulties like personal, the area problem, villagers problem. Give me some more time. That extension of time is also permitted. So time is not the essence of contract. 55 is contract. Now, when his application for extension of time was pending, ONDC placed the whole left out material in auction, sold it to third party. Now, he did not stop there. After selling it away, keeping my application for extension of time pending, he has imposed penalty on me and forfeited my yield. But what I say, when my application for this forfeiture of EMD, treating the left out material as abandoned or imposing penalty is not correct on the part of ONDC. I have also filed on IA that at least whatever you have sold, but this EMD which I am entitled to take back and the penalty which you have imposed, that's not correct.
Oh, so that's a monetary one.
Money place.
That's a monetary one.
Yes.
So far as the materials gone forever.
They have sold it.
They have gone.
Only to this extent now it remains.
So what entry model? They are not a fly-by-night operator that they will go.
It's not an incident.
So there is no difficulty. What's your stand?
I'm appearing for the OP1 mallet. Today I have received a copy of IR number 15,970. Today I received. So kindly allow 2 weeks time to file the objection because I will take instruction from the client and file the objection.
The point is very simple. He says that whatever is there, extension is permissible under the terms of the contract. And if the time being not the essence of the contract, then you have to communicate the decision. You have sold it in a hurried manner, whatever, I do not know whether the advertisement which you subsequently made, where the percentage of the FE content, I think, must have been reduced or shown less or the same.
Same.
Then his stand is not justified. That it has a lesser amount, whatever. But without giving an extension, how can you? Sitting over the same. File your opposition. We'll consider it 2 weeks, 1 week, 3 weeks. Let us say.
After 2 weeks,
Not after vacation means immediately 1 week, within 1 week after vacation. Yes.
Item 34.
After vacation.
It's called snakes.
34. People were and present for ultimately.
counter has been filed. I'm just trying to satisfy this honorable court. And despite filing for counter, I have a prima facie case to satisfy this honorable court for an intervention for interim relief. And so focal point of this entire litigation is that the basis on which my technical bill was rejected, the reasons were communicated after rejection of the bill. Is the entire basis of my case.
That is the when they can they provide you a reason for rejection of a technical bid before the decision is taken, or it is only after the decision is taken they will communicate to you?
Right away, answering my lord's question, there is a provision where if there is any shortfall in the documents, I would be communicated. If I fail to supply clarification / correct documents, my technical bid is liable to be
What was the ground for if your eligibility from your document appears to be not fulfilled? Then what remained? What clarification of the document is required?
My lords, my only ground is had there been an opportunity given to
That
me.
is not the.
In fact, my lords, the tender document.
So let us see that if the tender requires a particular amount to be deposited along with the bid, amount is not deposited. Clarificatory. Asking for the clarification. Is it not giving you a premium or extension of time?
If I may clarify, my lords, documents were submitted. They said.
What are the grounds for rejection?
Grounds for the documents submitted by them were illegible. We told them to resubmit the document, they did not submit.
Where is the
Yes, my lord,
where is the ground?
Turn to page 223 of my writ application.
223.
Yes. If I may, my lords, they said that.
Yes.
Sorry, my lords.
223. 10. Yes.
Page 223 is subsequent to my rejection, my lords. If I may read, my lords. You have not.
Yes. So they have given you a time to respond. You did not respond. They have said
that is the dispute, my lords. We have not.
That the clarification was sought in this regard. You have not responded to the same.
Well, that situation has never happened, my lords.
What are you talking about?
My lords, from the documents I satisfy, my lords. If I may, my lords.
Let him. He's a junior advocate. Let him get the full opportunity. Let them convince us. Let us see what he argues.
I'm so grateful.
Yes.
At page 63, my lords, there is a requirement that in event a bidder has a shortfall or an illegible document.
Sir, I understand. We appreciate. But kindly consider, if they have invoked that clause and they invited you to clarify, and if you do not clarify, is there any default on their part? This is the very first line they say that as per clause 3.1p of the additional terms and conditions, clarification was sought in this regard because you have not uploaded the legible copy.
My lords.
Then they say, however, you have not responded to the same. If they invite you to clarify, if you do not come forward and clarify, what is the wrong in it? I'm just asking you.
If I may right to answer my lord's question.
Please.
Well, that invitation to the petitioner to clarify can be only done through an email and by no other means as per that.
Where is the mode? Show us that this is the only mode, and they have taken that they have taken or they have disclosed that they have taken another report. Tell us. Show us.
Page 63.
Show us.
Page 63 would right to answer my lord's question.
Yes, please. Show us.
63.
Which clause?
My lords. Roman 2, my lords, clause B.
Roman
2 for two parts.
For two part system. Yes.
Clause B, my lords.
Yes.
May I read, my lords?
So they say that they will definitely upload
Yes.
those in the specified online
Yes.
for the app.
Yes.
And
Yes.
additionally, they may send the system generated email or SMS as well. And if you say that I have not received the email and SMS, will not be a ground for that. They have said that it will not be a ground. Now, what stand they have taken?
Their own document at page 198. Members.
Yes.
Their own document at page 198. Did Members file 198?
Yes.
Members, page 198 is a document. This document is subsequent to our complaint that we have not received anything. Numbers, they say in page 198 that they have sent an email to me at second paragraph. Subsequent to your representation, MCL referred the matter to the GEM team for verification in the response. The director VD email dated 1st of July confirmed that as per records pulled by GEM team, mail was triggered to the petitioner 7th of June 2025.
Yes.
Is that statement, Members?
Correct.
Now,
7 June.
Yes. Now, Members,
much prior to 1st July.
Yes, Members. After this incident has happened, then Members, my technical was rejected. Now, Members, I contested this statement that no such mail has ever been triggered.
Can you, after this specific ground that email, non-receiving of the email or the SMS will not be a ground?
Not because I am saying so because in the counter mailers, no such proof of email has been filed.
What is there? They have said nothing. Then it's not for interim order. Then it's a question of evaluation. You are pressing for an interim order? No, definitely not a case of it.
Last endeavor to satisfy this honorable bench.
Yes.
Now, my lords, because that is my specific case of non-receipt. I'm well aware of the settled principle that once the email has been triggered, the receiver cannot deny a non-receipt of email. But despite being aware of this settled principle, my lords, because this is my only case when this honorable court called.
So you are pushing more hard on that.
When this honorable court called for objections, my lords, everything was filed. There was no single document by the opposite party to show that yes, on 17th or 7th of June, such email was triggered calling for clarification from the petitioner. Would be my only statement to bring out a prima facie case for interim order.
They uploaded on the portal. Everything was done, which is in terms of that particular. Where is the clause? Which page?
That's
was the clause?
63 minutes.
Huh?
63 minutes. Roman 2, clause 3.
Yes. Yes. Anything more?
Absent these minutes, my only remaining humble submission would be there was no occasion for me to give the clarificatory document. That clarificatory document was regarding my non-blacklisting. That was the only document which.
So they have taken illegible copy. They wanted a legible copy, nothing more than that, and you have not supplied. That's all.
Only case in that minutes, there was no occasion for me to upload this. Everything was online minutes. If there is no option for me in the portal to click and then.
Sir, there is already that you can upload this.
It's an automated portal. Once there is a shortfall, it will show that I need to upload. But that button has never come. Because Annexure 4 and 5 of my writ applications are very telltale that that button has never come. Hence, minutes page 190 has come into being. But had there been a situation where I would have been given an online opportunity to upload those documents, I could have uploaded documents. So the entire case hinges on receipt and non-receipt of that particular email numbers.
Yes.
And in the counter affidavit,
I don't think so that there is no other issue which is involved, so we can dispose of the writ here and now instead of the interim.
But now price bid is not yet open.
Now LOI is an issue.
LOA has been issued.
Even if I may permitted to add the L1 bidder, because then we're not.
Yes, you then will have to change it also.
My lords, I have to
Amend the pleadings as well.
and the pair also, my lords. And I
Whatever. Yes. According to the council for that it requires any revisitation. Yes.
Item 35. But here the IA is for condonation of delay. Here the appeal has been preferred with a delay of only 14 days.
Only
Only 14.
serve the copy.
And sir, you'll also call this matter.
Yes. Issue service be effected immediately after vacation.
Okay. Item 36.
Service
36.
delay service. Who is appearing? None appears in support of the appeal. Let the appeal be. 2 weeks means give a date.
Please,
Service.
I have served the court.
Have you received?
I have received just now. Delay about more than 20 days.
7 days delay. It's as per the SR2.
And the
SR says 7th. His staff reporters talks about 7th. And if you have given an explanation of 20 days, then he is on a better footing.
he has given the explanation which may not be acceptable to the court if he also considers the explanation.
Your condonation application.
No.
Hey, I to sir. It comes only for admissions.
Here it was.
Yes, please. I was
Actually, it comes as a motion. There is a motion, fresh motion, adjourn motion.
You must say fresh admission and for admission method, and then after hearing.
Later on,
Fresh admission.
we introduced that fresh admission, thereafter orders, thereafter after notice. Earlier it was only admission, thereafter.
Before my time.
Yes.
Yes, fresh.
Born after that.
Yes, yes.
Next 38.
Pardon my item 36. I was coming by staircase. I couldn't reach. On the record, 15 days delay there.
Have you served?
Yes, copy has been served in mistake.
Who is appearing? Have you seen? 15 days. Same order, 36. Recall that. Fresh admission on 8th.
38, sir. Yes.
Here there is a delay of 112 days.
Serve the copy. Service.
Soft copy, sir.
What? What do you say?
The lordship will consider. The lordship's matter relates to regulation. 200 employees similar situation has.
What do you want? What do you lordship?
The lordship consider the delay. Here on merit can.
We are fixing this matter on 8th. With the conditions that you will argue on merit.
Condone the delay and
Argue on merit. On that day, we'll condone the delay. But argue on merit. Come ready on merit on 8th.
Today, my lord is ready. My lord is ready.
List the matter on 8th.
On both points.
No. But it's an understanding.
Because of tendency of the writ appeal, consent is not taking up.
That's why we are fixing the appeal itself, sir.
No.
8th. Yes.
Item 39.
Caveat.
My lord.
Have you received the copy, sir?
No.
Sir, why are you not? If the caveat is lost.
Impossible.
It appears that a caveat is lost by, what is your good name, sir?
Siddheswar Bar.
just come in order house because the annex of 8, the certified copy I could not file on the dispensing. I filed in the IA for dispensing with this copy of the order. And now this is a transfer matter. This is regarding transfer. The lady has been transferred to a 170 kilometers away. The matter.
You know, bring all the judgments in a transfer matter. How far the writ courts will interfere.
Only lenient bill may have taken, only a repetition may be considered with a distance because it is
What?
20 years continuing, 20 years of service.
So-
Other employees are continuing, but the lady.
Convince my brother, I am stuck with my own judgment.
Well, a lady, there is a small seeds are.
Sir, when main case is pending and the ladder judge has not
Only they did not entertain our.
considered a fit case to grant you interim order, then can you challenge it and it appeal?
Did not grant any interim order.
No.
Only.
The instant appeal arises from an order dated 4/8/2025 Condonation application served.
No, madam.
This branch manager indus
Bank material.
Service issue notice, file requisites by tomorrow.
2 days delay.
1 day delay accrued a right into the other side. So that right you cannot be defeated. But why you came delays so late?
To get the certified copy.
Sorry.
2 days delay.
Sir, you are intruding into a very difficult zone. Once you applied for certified copy, then the period of limitation stops. The moment the certified copy is made ready, then the period will start ticking. What you were doing after that? Sorry, whatever. Notice tomorrow by put in by next day, that is tomorrow.
Item 42.
I have already filed the certified copy. You lost me that on for RA. I have challenged the government at 2025 common service on the question of a transfer of the present petitioner who has been adjusted against the standard post method. I am taking easy for your losses interpretation. But when this petitioner was the contractual ICDS supervisor,
was a
contractual ICDS supervisor,
correct,
was posted at Rajnagar. He was transferred by the collector from Rajnagar to Kendrapara as contractor. But that I filed the writ petition. I filed the writ petition before, so as contractual employee cannot be transferred from one place to another place, this honorable court granted stay on the basis of judgments of this honorable court. No, 2 or 3 judgments of this honorable court. I cited that. Therefore, interim it was stayed, my lord. While it was stayed, my lord, the government took a decision to regularize them as the permanent supervisor, ICDS supervisor. But there it is the ex-cadre post pilot, supervisor post has been created, and the post is created for that person only. My your lordship time come to page.
Post is created for
that person. Your lordship time come to page 36, my lord.
Then,
my lord, I am placing that person. Your lordship,
let us for that person.
The post so created is personal to the employee for whom it is created, and no other employee can be appointed against such post. This is the language. It would be stated, it would stand abolished as soon as employee for which it is created vacates it on account of retirement or confirmation in on any other regular permanent post or for any other reason. This is the language, my lord. Then the petitioner was posted as Rajnagar, my lord, against that post created regular post, my lord. That the transfer order which was made, my lord, prior to that, it becomes infructuous, my lord, invalid, my lord. According to my submission, my lord, that is
earlier what was the transfer order?
Transfer
from contractual to a contractual.
Contractual to a contract.
That's all.
Then she was posted as Rajnagar under at page 5, my lord.
Yes.
When, my lord, the writ petition was heard by the Honour Single Judge, I submit before Honour Single Judge that it was transferred from contractual to contractual. Becomes infructuous. Now I have been posted against the post created for me at Rajnagar, and I cannot be transferred from that place until retirement. I retire on 31/7/2027. The Honour Single Judge held that no, it is the service jurisprudence. A post cannot be created for you and you cannot continue in that post
perpetually.
Perpetual, not.
That's true. Perpetually means till you attain the.
It has been, my lord, at the verge of their retirement, they have been regularized. They have sought for a long period as contractual employment. Therefore, language has been used by the government that till their retirement, my lord. Therefore, till my retirement, 27, my lord, July 27, I will work that against that post. On my retirement, that will my.
So where is the question, sir? The transfer order was passed when you were contractual. Subsequently, you have been made permanent at a particular place.
By creating a.
Now, subsequently, have they or pass any order of transfer?
No.
So then, what is the ground for challenge? I fail to understand.
I have not challenged. Therefore, I submitted before Honorable Singh. It becomes infructuous, and it is not necessary to proceed on. And the Honorable Singh just passed a judgment on that. The lawsuit can come to.
What was the necessity, sir? If a post was permanent post is created, sanction post is created, where the contractual appointment, he has been absorbed or regularized at a particular place. When there is no question of any transfer, because you have not taken any decision to transfer after that, then the writ petition challenging that transfer order when he was a contractual employee becomes infructuous.
Yes.
There was nothing to decide on that. If you pass a subsequent order of transfer, no difficulty.
Obligation.
You have to regularize thereafter and thereafter. Before.
But he was as a contractual employee, he was transferred as a contractual employee.
By the time he transferred, he was a contractual employee.
So if a transfer order is passed, then from a contractual post to another contractual post, now he has become holding a permanent post. Can he be transferred to a contractual post? Cannot.
That is a permanent post to which he has been transferred, man.
How? Without regularization?
Regularization has been done already. Subsequently, it has been done up. After transfer.
Can it be?
That is what paragraph 8.
8, man.
It can't be.
No, paragraph 8, Learned Assembly has made it clear. And further adjudication was redundant then.
Yes, ma'am.
It was redundant. It was not required at all.
However, this court refrains from entering into the question as to if a contractual employee can be transferred or not, because as argued by Learned State Council, the same has become redundant upon regularization of the petitioner's services in the meantime.
Yes, ma'am.
That's all. Full stop.
Yes.
Matter would have ended, and the writ becomes infructuous. Putta quittas.
Then reference to the resolution dated 24 would reveal that the government decided to regularize the services of contractual ICDS supervisors working in the. So there are the issue was whether if he could be transferred while he was serving as
contractual.
The further issue was redundant.
Not required.
When
Infructuous.
itself had become infructuous.
I submitted that.
A writ petition was filed. It goes. Let's call the next.
Item 43.
Delay, service.
Action has been brought on by Lalit Senior Miller.
Is he appearing?
It is here.
His previous.
Has he instruction? Has he received any instruction to appear here also? Oh, you have.
4 days, huh?
Four.
Well, condone.
Same order.
But the rate appeal, in fact, is not.
Eighth for fresh admission. Eighth for fresh admission.
Actually, the predicament is not only can I submit my.
Then you should have been very prompt in filing the appeal. If you are a delay, no.
I filed it on 26/8.
So whatever, then the condonation application, why it is?
It will be on 5th October.
What?
5th October.
What eviction proceeding?
Eviction of the OPTCL premises quarters.
He himself admitted that he will vacate the quarters. The lease periods have already been expired since 2018.
Oh.
Because 2018 lease period expired. And that also you can see the London single just order.
Eviction notice were admittedly not issued by the.
If the lease expires, does it require any notice to be served?
PPI.
Oh.
It's a Public Premises Act by the estate officer. Here the estate officer.
Estate officer?
Yes, my lord.
Then section 4 notice.
Yes, my lord. That has not been sent. And though admitted the laminate.
Did you participate in the proceeding without any notice? How you have given a reply under section 5?
Proceedings. My we appeared before this court by filing a writ application, then opportunity was being heard. Thereafter, they have to issue those eviction notice afresh under OPP Act, my lord.
What is the definition of unauthorized occupant under this OPP Act?
Yes, ma'am. Unauthorized occupants is beyond the lease period if someone is. Actually.
In PP Act, it is 2G, but
Yes,
here what is the?
Yes, my lord. In relation.
Oh, here also 2G.
Yes, ma'am. In relation to any public premises means the occupation by the.
Same definition, I understood. It's the same definition. Section 4 is the same.
The eviction notice which was issued earlier, there were no mention of unauthorized occupants about us. Because by the.
What? Section 4 notice was not given. What are you talking about?
Eviction.
24.
Eviction notice at page 62.
This is item number 43. 43.
Page 62.
Page?
Page 62.
Yes.
That is not by the estate officer. Estate officer has to be appointed. Thereafter, eviction notice has to be issued under section 4. Thereafter, section 5 has to be issued by law. Final order on eviction.
So this is a notice of vacating the premises. So section 4 notice is not served. Where is it?
9/4/2025, the OPTSL authority in fact issued notice for vacation. But
That is the eviction notice. That is eviction. But what about section 4?
That's correct. That's correct. But HON'BLE person can see not single just order person.
Yes. Oh. Then you can't maintain it.
Where the quarters are unsafe. Here the quarters are unsafe.
Honorable Apex Court.
That after giving an undertaking, the SLP can be filed.
Here it is the same issue that the appellate counsel they have assured before the writ court that they will provide the quarters. And again, they challenged before the Honorable Apex Court, and Apex Court was the single judge, Honorable Single Judge order. My lord, kindly have a glance to para 32. Para 32.
Para 5 and 6 of the Senate set.
My lord, it is also not in the presence of OPTCL. My lord. Not in the presence of OPTCL. No notice is required to be issued.
The quarters are unsafe, my lord. What happened when the quarters are unsafe? For a subgrid station, we want that quarter should be demolished and other things are there. It is a public.
Are you accepting that you have made this submission? I am asking you. Are you accepting that this submission was made by you?
Not, my lord, we are not the council, my lord. Other council who have appeared.
I am asking you, did you?
Yes, my lord, they have, it is written that they have fairly submitted.
So you go by this, that this has been submitted.
It is fairly submitted, that has been.
Then you will have to accept that it was fairly submitted before the single bench. You can't contradict.
Out of my lord. This is the judgment where I am going.
Now paragraph 10. The concession on fact and a concession in law, what is the distinction?
Here there is no.
Show me the relevant portion.
My lord, 32.
32.
Yes.
Yes, please.
Was there ready for them?
Just.
Yes.
When I asked this question to you was taking into account knowing fully well this, as long as they are unequivocal. Where, however, doubt exists as to the purported admission was really admitted or not admitted, the court should be wary to accept such admission until and unless the counsels or the advocate is authorized by his principal to make such admissions. So the court will not accept such admission unless he has received an instruction with him that I have been authorized to admit. A lawyer generally has no implied or apparent authority to make an admission or a statement which would directly surrender or conclude the substantial legal rights of a client, unless such an admission or a statement is clearly a proper step in accomplishing the purpose for which the lawyer was employed. Means principal must have instructed him. We hasten to add, neither the client nor the court is bound by the lawyer's statement or admission as to the matter of law or legal parameters. If there is a concession of law, no admission in eye of law. Thus, according to generally accepted notions of the professional responsibilities, the client's instruction, rather than substitute their judgment for that of the client. That's a sermonization that they should not do. They must be very cautious. We may add that in some cases, lawyer can make decisions without consulting the client, while in other, the decision is reserved for the client. It is often said that the lawyer can make decisions as to the tactics without consulting the client, while the client has a right to make decisions that can affect his right. How it helps in this case? You were not the counsel who appeared before the single bench. You do not know whether your client has given an instruction to him to admit.
Or what happened also in that?
Just, reminding her of AIR 1982 Supreme Court as well. A.R. Antule's judgment.
Yes.
State of Maharashtra versus A.R. Antule, 82, 1-4. Ramdas Srinivas Nayak. Ramdas Srinivas. 1-4-7-9-5.
Go to the concerned court.
We will not. You can't. And there is not directly involved in this case, but there is another judgment of the Supreme Court, AIR 1997, Supreme Court 1005, where the Supreme Court has said that changing the lawyer frequently at the different stages and making a new case or a new way of arguing is not permissible. That was in case of a review matter. So I'm just saying, it is not directly, factually, you will not find parity, but the ratio one can draw from there, or inspiration can be drawn from there. You can't. This paragraph 32 is that he can make a admission, if he is instructed by his client. You do not know whether he is instructed or he is not instructed. No, sir. Then you will have to go to the same judge by virtue of Ramdas Srinivas Nayak judgment. No.
My lord, can I pray? My lord, at page 8, my lord, kindly have a glance to page 8. Only innocuous prayer. Only 6 months may be granted to SBI.
No.
My lord,
Again, the third counsel will come. Again, the third counsel will come that how can she make this admission or prayer without my instruction? You are defying the statement of your in the single way. Now somebody will also defy.
The buildings are not safe.
No, madam. No.
Quarters are not safe, my lord, also.
No.
Puja is ensuing, my lord.
Yes, sorry.
Because it is a small room.
It is only a oral request to him.
Yes, my lord, that is how I am requesting him to, my lord, only that much observation that he
arises out of a PLE proceeding. Orissa Prevention of Land Encroachment Act.
Okay, OPLE.
OPLE.
Yes.
The impute order or the order of the Honorable Single Bench is an annexure 3-page. Before going into the facts, I'll just place some impugned order. Then I'll take
what?
The
Take appropriate space is a steps as per law for making disputed question encroachment free.
Encroachment free.
Why?
Based on the report submitted by the London Court Commissioner.
It's pertinent to mention that
Court commissioner means
court commissioner was appointed by the honorable single judge. In order
to go and find whether you are in possession or not.
if I am in possession or not, what is the extent of land encroached by me? All those aspects to have been considered as a court commissioner.
You pass an order of eviction?
Yes,
Or
my lord.
it says the notice of eviction is challenged.
Yes, ma'am. That order has been passed. I'll fairly also submit that this same order was challenged in the appellate forum. The petitioner had lost that appeal. It was again revised as per the act. A revision was filed before the collector. That
also dismissed.
Was also dismissed. But
no further challenge.
No, a further challenge was made to before this honorable court, before the honorable single bench.
And in this writ petition?
No, madam.
Earlier, that was also rejected.
That was allowed. So
allowed means?
That was allowed to that extent, my lord, because there is a revision case pending. Now there is a dispute between the actual extent of land that I
No. Why it was allowed?
Before directly answering that, my lord, some basic premises required. So the appellant here purchased 40 decimal of land, madam. But during consolidation operation, when the map was prepared, the map shows that the private plot is of 35 decimal and 5 decimal is amalgamated in the road, madam. So I had challenged map before the concerned authority. Now, because that revision was pending under the Consolidation Act, the Honorable Single Judge in the previous writ petition stopped the Tahsildar from carrying out the eviction order till that consolidation revision is considered.
So that is not disposed of.
No, that is now disposed of.
Did not find your contention to be correct.
No, it was not disposed of under merits, my lord. It was disposed on the grounds of maintainability.
So whatever, the dismissal is there.
Dismissal is there. So now I filed a writ petition which is pending before this honorable court.
Or any interim order, because the single bench has said that so long that is not decided, no eviction, then you could have renewed the prayer. Now it's a continuance. Did you get any order?
That there lays the foundation of my submission, my lord.
I am asking you, in that writ petition where you challenge that order of dismissal, did you secure any interim order?
No, before that in that writ petition, my lord, I humbly submitted that this writ petition, an interim order is passed. So the honorable judge was of the opinion the matter is ongoing parallelly. He should not pass any orders as of now, so as to ensure that there is no parallel conflicting orders being passed by this honorable court. So that's why the said consolidation matter, it is still pending, pending for adjudication. It has been admitted, my lord. That's also a fact that has to be gone in. So now there is a clear cloud of title over the land from which the state authorities are trying to evict me, man.
So is that para 4 that is grievance is settled. I am telling you, para 4 is settled. They have not found out the commissioner went there. He did not find out whether the portion of his purchased land has been mixed up with the government land with subject matter of include. And that is, he has said in para 4. With the
Who is the court commissioner? Who is the court commissioner?
Court commissioner
and advocate commissioner was engaged.
So that was a physical, the inspection.
Yes, sir.
Do he has an expertise of reliance survey of the properties to identify the measurement exact location?
That is the chief manner. But with all fairness, I submit para 4 can be answered by superimposition of the survey plot with the present consolidation plot, so that it can be ascertained whether his land is mingled with the government plot or not. That is, but nobody has answered that. The commission has also answered that.
A point involved in the Sir, come with those line of judgments because it says that the report of the commissioner is merely an opinion evidence.
But there
And if any judgment is passed solely on the basis thereof, it is not permissible. My own judgment is there. I have held. Bring those line of judgment. That's the only point.
To para 4 of each prayer that can be resolved, my lord.